Dr. David Udy. I was the health service administrator for the Las Vegas City Jail and the Henderson Detention Center for several years, so I know the Metro Police Department and a lot of their personnel very intimately. This issue, this new bill, is really fundamentally an issue of low-hanging fruit. If you were working for the Metro Police Department and you knew their situation, the issues they confront every day, you'd realize that it's much easier to deal with popping somebody who has 10 pot plants rather than somebody who is selling crack cocaine. That is the fundamental issue here, and anybody that supports this bill in the climate we have today with the economic conditions should be ashamed of themselves. We have other issues of violence, recidivism, and plenty other problems that the Metro Police should be focused on.
Today to speak out against Senate Bill 262, mainly because it addresses areas that aren't cleared up with previous legislation, mainly NRS 453A. Currently, my family has 3 members that are licensed patients, with 2 more coming through the pipeline. Also, we have about 45 additional friends and relatives that plan to enter the program within the next 30 to 60 days. The limits that are in place on growing cannabis are unfeasible. Anybody with an 8th grade science education knows that if you put 7 seeds into dirt and add water, there's a good chance that most of them aren't going to sprout. And in the cannabis community, there's a good chance that some of them are going to sprout as males, which most of us know make them worthless. All we're asking for is a little bit of cleanliness to the 453A and the elimination of Senate Bill 262. We already have federal penalties in place. There's no need to add more when the state already handles this.
Senate Bill 262 is a bad bill because not only does it target patients for growing over 7 plants, which some patients need more medicine. The current medical marijuana law in Nevada does allow for growing more than 7 plants under medical necessity with a note from your doctor saying that you need more medicine. But it also is adding racketeering charges and intent to sell for just having one more plant over your 7 limit, which is not fair to patients who need their medicine. Other states such as Washington have shown that the limit amounts are much higher than what we have here in Nevada, and if they're going to be making changes to bills, they make things easier on patients rather than harder.
Here in protest of Senate Bill 262. My name is David McDonough. I live in Henderson. 262 is just going the wrong way. It makes criminals out of medical users who happen to have a large quantity usage. I'm one of them. I like to smoke for the relief, about an ounce a week. And to supply this by the current standards is impossible.
I am actually here about the medical marijuana program. I wanted to definitely tell you that I'm a normal person. Actually, no, I'm not. I had a stroke. I have been on the medical marijuana program for a year and it has saved my life. You're going to put me on morphine, my life would have been over. Now that I'm on the medical marijuana program, I have other alternatives for my pain, my anxiety, and all the stress that comes with that. But I wanted to tell you that I think that medical marijuana for patients who are sick is very, very important, and we need to really, really dive more into it and really help other people. And I want to thank you very much.
Hi, my name is Christina Monroe, and I'm here because I believe in the marijuana program. I have several conditions which include glaucoma, cirrhosis of the liver, MS, rheumatoid arthritis, cancer. I'm blind in one eye. I'm losing the loss of my legs. Without the marijuana, I can no longer eat because I throw up. I end up in the hospital. The marijuana actually helps me survive. If not for the marijuana that I received, I would have by now committed suicide. So please, please, we are asking you to help us.
262 is severely flawed for a number of reasons. First off, it establishes a hard limit of 7 plants when clearly, according to both federal distribution of 300 grams per month to the patients on the federal program, and Washington State, who has a medical marijuana program, has done a study showing 8.24 grams per day as being the medical dosage that is required. And clearly 262 will not allow that to happen in so much as it's practically impossible for anybody growing, certainly indoors, to get that kind of yield with 7 plants. And so the bill, by putting a hard limit, is an intent by the legislature to override the people's initiatives of 1998 and 2000, which legalized medical marijuana in this state. On top of that, by labeling this a racketeering crime, it makes it much easier to do asset forfeiture on people who are convicted of this crime. This bill is nothing more than an attempt by Metro to grab assets from any number of people. And even though Metro says, well, give us the power and we're only going to use it in those most severe cases, we have seen with the Patriot Act and with others that any time that a power is given, it is inevitably abused. So we're very much against it for that reason. Furthermore, the law labels growing of cannabis to be an act of immorality, which is social conservatism. Where is the science of that, where the rest of the country is moving towards decriminalization and liberalization of these laws? To call the growing of any plant an act of immorality is just absurd on its face. Beyond that, the law will also put people at risk who, if they're growing 8 plants, the law says that it's a prima facie case for distribution, and that makes it easier to lump it in with racketeering and take the assets away. So it's a fatally flawed law, and we're trying very hard, the activist community here and the patient community, to get this thing overturned. Because even though the DAs and the police say we're not going after medical marijuana patients, in truth, they have. Pierre Werner is a living example of that. I'll give you another example. A fellow named Reggie Morgan, who's a licensed patient, has been for years, a liver cancer survivor, and he's managing his disease. He got pulled over on the highway by a Nevada Highway Patrol officer, who, when she saw his medical marijuana card, promptly arrested him, subjected him to a blood test, and they charged him for driving under the influence. And as such, they suspended his license, and they were holding him over for trial. And he appealed to the DMV, and the DMV ruled that since he was a lawful participant of a state program, the THC and the cannabinoids were not a prohibited substance in his bloodstream. And were they to say that he could not drive with that, they would have to make the same determination for anybody who's on OxyContin or hydrocodone or Valium or Prozac or any of those things. And they were unwilling to do so. And so they reversed the suspension. And that kind of pulled the legs out from under the DUI case. The problem was, he already spent some time in jail. He had to spend some money on lawyers, and it was a miscarriage of justice. So for the police to say, and the district attorneys to say, well, give us this power, but we'll use it judiciously, it's not borne out by the facts.
The government hates to admit that they've already acknowledged that marijuana is a medicine. They acknowledged it in the 1970s and 80s when they allowed dozens of Americans to receive a monthly supply of marijuana from the government's marijuana farm at the University of Mississippi. Some of those people are still alive and still obtaining it today, their monthly canister of marijuana.
Receive 1 tin of 300 pre-rolled cigarettes, approximately 300 cigarettes, every 25 days from the federal government.